Okay.
Yes,
Mr.
As a,
Baloi, fine.
as the court pleases, the essence of this exhibit, this document, appears on page 2.
Page 2.
Under paragraph 1, that there were no transactions on this account for the period 25 October 2014.
Period 25 October 2014
to 28 October 2014.
No transactions.
Yes.
Okay.
Mshishisi uthi-ke Mr. Ntanzi akufundayo noma-ke ku-page 2 wale document-ke yasebhenki ayifundayo ukuthi page 2 wakhona uthi kusuka ngazo i-25 zika-October 2014 kuze kuyoshaya i-28 zika-October 2014 akukho okwenzeka kuyona le account noma akuna transaction eyenzeka ngaleso sikhathi leso.
Yes.
As the court pleases, my lord. As indicated yesterday, my lord, the state is now at a point where we want to present the various statements made by the accused persons. The state is in possession of a confession as well as the pointings out made by accused number 1.
Kulesi sigaba ke umshushisi uthi bewumbuso ke bafikele kwisigaba lapho namanje befuna ukuthi ke bothuleke izitatimende ezenziwa ibona abasola lokubiza ukuthi ke confession noma ukuvuma ke kanye futhi nama pointing out ukukhomba okwenziwa uyena uaccused number 1.
The state is also in possession of 2 confessions made by accused number 2.
Kanye futhi ke nama confession noma izitatimende ke zokuvuma noma ke ukuvuma ezenziwe uyena uaccused number 2 ezimbili.
The state also intends to lead evidence on the warning statements of all the accused.
Kanye ke nama statement noma lokho kubizwa ke ukuthi ke ama warning statement izitatimende ke zokuxwayiswa ezenziwa ibona bonke abasola.
As far as the confessions are concerned, I've been informed by Mr. Ramusipile that the admissibility thereof is being challenged on various grounds, which they will in due course advance.
Ushilo ke advocate Ramusipile noma ke umeli Ramusipile ukuthi ke iqiniso ke elikhona ke kulezo statement ke ekuthiwa zenziwe ibona ke abamangalelwa nababasola abamele uzophikisana ke nabo.
And that applies to the pointings out as well.
Kanye nalabo kushiwoyo khona ke ukuthi ke umangalelwa wabo uqala wahamba wayokhomba khona.
As far as the warning statements are concerned, the position is not yet clear. I'm yet to be informed by my learned friends what their position is regarding the warning statements.
Mayela ke nale izitatimende lezi ezithathwayo ke uma abasola beboshwa lokubizwa ukuthi ama warning statement ke angikazi ke ukuthi lapho ke kuzokwenzekani abameli abakangitsheli.
But be that as it may, the state will request that one trial within a trial be held regarding the admissibility of all these documents as the evidence is interlinked.
What are you saying now?
I'm saying that when we get to that stage, my lord, we will request that one main trial within a trial be held to determine the admissibility of all these documents, my lord.
I know no law like that. Because the confession doesn't bind a co-accused, as you know. Is that not so?
That's indeed so.
Yeah, so if there's a conflict, for instance, in that regard, what does the court do?
Yes, but what we mean is, for instance, my lord, we are avoiding a situation where we determine the admissibility of accused number 1's confession. We hold one trial within a trial,
Right.
then we go to accused number 2,
Right.
determine the admissibility of that confession,
Right.
hold another trial within a trial.
Yes, that's how it has to be done.
Yes, we're trying to avoid that piecemeal way of holding a trial within a trial, as we pointed out that the evidence is interconnected, my lord. So if we hold just one trial within a trial, we will then avoid the situation where we hold the trial within a trial in compartments, my lord.
Now I hear you. So you want to hold one trial within a trial in respect of all the affected accused?
Yes, indeed, my lord.
Regarding the admissibility of whatever,
Yes.
pointing out of statements. Or.
Indeed, my lord.
Okay, let's just read what are your duties so that we understand it. This is the do it's not me saying this. Duties of the prosecutor. It is, in fact, the duty of the prosecutor first to investigate the circumstances under which the statement was made and to establish whether it amounts to a confession or an admission. I quote the case as Bonzi, 1985 for SAA 544. If the prosecutor is in doubt, it is his duty when raising the issue in open court to warn the presiding judicial officer, who must then investigate first whether the accused made the statement, and if so, whether it is a confession or not. So let's pause there. Mr. Ramsipidi, your client, has he just made a statement, or has he made a confession, or has he made admissions?
My Lord,
I know we are disputing the admissibility
Yes.
of them, but what are you saying?
it's a statement, my Lord.
Now, but listen to me carefully.
Yes.
Has he made a statement? Or has he made a confession?
Yes.
Or has he made admissions?
My Lord, let me clarify from my perspective. My instructions are that he never made any statement.
Yeah, so you must tell me that.
Yes,
So your client denies that he made a statement.
indeed so, my
And
Lord.
he also denies that he made a confession.
Indeed so, my Lord.
And he also denies that he made admissions.
Yes.
Okay, fine. Right, this further says it is appropriate for the presiding officer to conduct a preliminary inquiry to determine the nature of the statement before a trial within a trial is held in respect of the further questioning relating to whether the statement was freely and voluntarily made. You hear what they say? You say your client never made a statement,
He never made a statement.
as juxtaposed to say the statement which the state alleges your client did make was not freely and voluntarily made, it was coerced. You're not saying that. Just think about the law.
My Lord, this is the position, as I was explaining. The making of the statement needs to be clarified because he says a statement was brought to him, he was assaulted, coerced to sign that statement.
Okay, fine. I hear you. As opposed to saying he never made a statement. When you say he never made a statement, it means no statement was made by your client. He can't make a statement because he was coerced to have made a statement or forced, as you say.
That's exactly.
So what are you saying?
My Lord, this is the position. He made a statement because he was beaten up, assaulted,
That's it.
abused
Yeah,
to
fine.
sign that statement.
Okay, fine. Now appreciate it. Okay, fine. Okay, and then the law says, it is appropriate for the presiding officer to conduct a preliminary inquiry, as I'm doing, to determine the nature of the statement before a trial within a trial is held in respect of the further questions relating to whether the statement was freely and voluntarily made, particularly where the parties are in agreement that the nature of the statement may be determined from the document alone without recourse to the evidence directed at its proper construction. But you say it was never made freely and voluntarily.
Indeed so, my Lord.
Okay? Yeah. Okay, my former colleague, Salduka, in the case of S versus Gamma, 2013, it's an SAA case, unreported. Case number 127/13, delivered on the 27th of September 2013. This is what he has to say, among other things. That the court is obliged to tell the presiding officer whether in fact it is going to conduct a trial within a trial. And this is how he points out it wasn't done in this case. He says, it is a disquieting feature of the appellant's conviction. The trial court had relied on a confession made by the appellant, but the prosecution had at no stage told the court that evidence of a confession would be led. But in this case, you are saying you intend leading evidence of a confession.
Indeed, my lord.
Okay? They say if you don't tell the court that, it amounts to a fundamental miscarriage of justice. And if there was any doubt as to whether the appellant's statement amounted to a confession, the prosecution was duty-bound to inform the trial court accordingly. A preliminary inquiry should then have been held to determine first whether the appellant had made the statement, and if so, the nature of the statement. Whether that is, it amounted to a confession. If it was found to be a confession, a trial within a trial would have had to be held to determine the admissibility of it. And it would consequently would have been for the state to prove the requirements for admissibility. The prosecution's failure to comply with its duty and the absence and the statement, its admission in these circumstances offended against the appellant's right to a fair trial. Where, as we know in our law, a trial, our law demands that a trial be conducted in accordance with the notions of basic fairness and justice. They're quoting the case of State versus Zuma. It's a judgment by Kentridge. Right. I had to read this because I must satisfy myself that either a statement was made or either a confession was made. And this relates also to a pointing out, because it is a genus of a confession, a pointing out, and can also amount to an admission. Okay, so I'm satisfied then that your client, according to, alleges that he didn't make a confession, but the state alleges that he did make one. Then you need a trial within a trial to enable the defense to contest the admissibility of that statement or confession. Okay, right. That pertains to accused number 2's position. And accused number 3's position, if any.
Yeah, it's, as we mentioned, it's accused number 1, there's a confession and a pointings out.
Yeah.
And accused number 2, there are 2 confessions.
Right. And number 3?
Number 3 up to number 5, those are just warning statements.
Warning statements, okay. Fine, so the trial within the trial will encompass accused number 1, 2, and 3. Sorry, 1 and 2.
Yes, 1 and 2.
At this stage.
Yes, and also request that the warning statements, if they're going to be contested, that they also form part of the trial within the trial.
Okay, fine. We'll come to that when we are through with Mr. Ramusipidi. Right, so the basis of your defense regarding the admissibility of the statement allegedly made by your client, it's what, Mr. Ramusipidi?
My Lord, are we at that stage?
Yes, we have mentioned assault. I must know, on what
Yes.
basis are you contesting it?
My Lord, let us take a short adjournment for that.
Why do you want a short adjournment? Because the law is clear. You tell
Yes.
the court, for instance, you've told this court that your client was coerced into making a statement by being assaulted, right?
Yes.
Any other reason?
My Lord, let me speak individually. Accused number one, he was assaulted
Yes.
over a period of time.
Right, I'm writing, by the way, right?
Okay, yes.
Number one was assaulted over a period of time.
Yeah, he was arrested on the 16th of June 2020.
Okay, wait, 16 June 2020,
Yes.
and assaulted.
No, he was assaulted from the 19th of June
Assaulted from the 19th of June
2020
2020
until he was taken to court in,
Yeah,
but that's why I say we must take a short, because the consultation is written in my notebook. So,
Okay.
yes,
How
let's
long?
take a short adjournment. 30 minutes, my Lord.
okay, what's your time there, Mr. Balwe?
It's 11 o'clock, my lord.
11 o'clock?
Yes.
Will you come back at 11:30?
Indeed, so, my Lord.
Okay, 11:30.